All right, so I think we're all set. Good morning, good afternoon, or good evening in TBDC, and welcome. I'm Julia Georgia, Senior Fellow at MEI's Frontier Europe Initiative, and it is my pleasure to welcome you all to today's event on Georgia's case at the International Criminal Court. MEI's Frontier Europe initiative, launched in October 2019, explores the Black Sea as a key region for transatlantic security. And with today's event, that is part of our effort for Black Sea security and dialogue, we will look at Georgia's case at the International Criminal Court, as well as the recent ruling of the European Court of Human Rights. We are fortunate to be joined today by Justice Renate Winter, Ambassador Norman Eisen, and Georgia's Deputy Minister of Justice Beka Zamashvili, who will lend their perspective on these two cases and their implications for justice following the 2008 war in Georgia. And I am honored to welcome Justice Renate Winter, Vice President and former President of the Committee of the Rights of Children. She served as President of the Special Court of Sierra Leone and is now a member of the Residual Court of Sierra Leone. Justice Winter has an impressive career and a long-standing career in international law and with the United Nations, and has served as a judge since 1981. Welcome, Renate. It is also my pleasure to introduce His Excellency Norman Eisen, Senior Fellow at Brookings, former US Ambassador to the Czech Republic, and former White House Special Counsel for Ethics and Government Reform. He has also served as a counsel for the Democrats on the House Judiciary Committee during the impeachment process of President Trump in 2020. And we managed to steal him away from what I heard. He's finishing his book just to talk about Georgia today. So thank you for joining us, Norm. And finally, last but not least, I would like to welcome Georgia's Deputy Minister of Justice, Professor Beka Zamashvili. He previously served as the head of the Public International Law Department and then as the government agent of Georgia to the international courts. In his capacity, he represents Georgia before the European Court of Human Rights and coordinates relations between Georgia and the International Criminal Court. Beka, thank you for joining. To read the full bios of today's distinguished speakers we have with us, please visit MEI's website. I look forward to taking audience questions through Zoom's Q&A feature, which you can all find on your screens. For those calling in by phone or watching our panel on live stream, you can ask a question by emailing events@mei.edu or tweeting us at MEI Frontier. If you have any technical issues, please email events@mei.edu. Feel free to please ask your questions anytime throughout the panel. I'll be looking at all of your questions and will factor in as many as possible into our discussion today. So with that, we will begin. Just a very brief outline from me in what we're looking at today. Following the 2000 war in Georgia, the International Criminal Court opened its first investigation into alleged war crimes and crimes against humanity committed in and around South Ossetia. This is the first full ICC investigation outside Africa, and while Georgian authorities fully cooperate with the ICC and have initiated this case, since the 2008 war crimes, Russia does not recognize the ICC. At the same time, last week, the European Court of Human Rights ruled in the case Georgia versus Russia. This case was initiated in 2008 by Georgia, and Russia does recognize the ECHR. Following the European Court's ruling, Russia can be held to account for acts of torture and ill treatment carried out during the 2008 war between Russia and Georgia. And we're here today to discuss what these two cases mean for Georgia in its pursuit of justice. And I'd like to start the discussion today with Professor Zamashvili. You have followed closer than anyone Georgia's ongoing case at the ICC, and I believe your former supervisor, Gocha Lordkipanidze, was unanimously elected in December 2020 as the first Georgian to represent Eastern Europe at the ICC. So can you give us a brief overview of the case, of the Georgia case at the ICC, and what these latest developments mean for Georgia?
Thank you, Yulia. I would like to thank organizers for this event, and I would like to greet all the attendees. You rightly underlined in your introduction that this case is very important not only for Georgia, but for the whole ICC system, because that's the first case beyond African continent. And that's the first case when ICC, International Criminal Court, investigates conflict which is interstate, international armed conflict. And considering the party engaged in this conflict, definitely the complexity is even raised. For Georgia, which is one of the founding member states of the International Criminal Court, and who was among the like-minded group of states who propagated establishing strong international criminal court. Of course, this court has particular dimension for us because Georgia has always sought to resolve disputes by legal means only, and our practice demonstrates that we try to apply and use all possibilities, all international courts. As you said, International Criminal Court investigates this case, and in parallel, there was ongoing case that was the judgment was recently delivered by the European Court of Human Rights. And just to add on that, Georgia has another interstate case before the European Court of Human Rights. This is case that was initiated in 2018, and the last case concerns the ongoing violations due to the ongoing occupation of Georgia's regions. We see ICC investigation and European Court of Human Rights judgments and the cases in the same prism, because for us they would complement the case rather than collision, cause collision, because definitely the scope of International Criminal Court and the scope of European Court of Human Rights are absolutely different. But at the end of the day, they are examining the same case, same armed conflict, and the same actors. That's why we think that the judgment of European Court of Human Rights would have influence, certain type of influence on ongoing investigation by the International Criminal Court. Of course, this is absolutely independent and separate International Criminal Court. But for example, what was the main finding of the European Court? For us, the main finding was that Russia is still occupying Georgian territories. And by the way, that was explicitly mentioned, the terminology as occupation was explicitly mentioned in the court judgment. And the second very important finding of the court was there was ethnic cleansing committed by Russia during this conflict. International Criminal Court now has to find who was most responsible for these crimes, and the scope is different. They have to identify the individuals rather than states, but that's the same war, that's the same conflict, and we feel that we hope that European Court's judgment would have positive consequences also for ongoing investigation by the ICC. I'll stop my introductory statement here, and I would rather continue on the basis of the questions that attendees might have.
Thank you, Becca, for this introduction into what are complicated cases at both the ECHR and the ICC. Let me turn to stay on the ICC topic to Justice Winter. The ICC case has limited bearing in its result, as I mentioned previously, because Russia does not recognize the court's authority. So from your perspective, what implication does Russia's and of course South Ossetia separatist authorities' lack of cooperation have for the resolution of the ICC case? If you could unmute yourself.
Sorry, yes.
Perfect.
Hello to each and everyone. I'm very happy to be here. It's the very first time that I am with MEI, sorry. And as you can hear immediately, English is not my mother tongue. So I will try at least not to make too many mistakes. Coming to your question in the ICC, I do think that first of all, we have to deal with the ECHR because it looks as if they would give the basis for the possibilities of the ICC. Becca has already mentioned the judgment now. And there is one thing that is absolutely important because of the forthcoming ICC investigation. The court in Grand Chamber has said, has spoken about the jurisdiction. Because, and this is very important because Russia always has said that they have no jurisdiction over Ossetia. It's not their country. This is an independent country. And so they are not even a party. And that was one of the big issues of the CHR, because they had now stated that Russia did not have jurisdiction in the active phase of the hostilities, but afterwards. And this afterwards is established through the meaning of what we call effective control. In international law, we have a system where it is said that a state has its territorial control and in jurisdictional cases also extraterritorial possibilities. But in any case, if this state is occupied by another state, this other state who effectively controls the country has a responsibility for what is happening in this part of the world. And this is one of the important parts of this judgment, because it says after the war, immediately after cessation of the hostilities, it is Russia that has effective control over Ossetia and the South Ossetian part as well, and thus is responsible for what is happening there. So already we have established the responsibility of Russia. Russia is bound by the ECHR. Is not bound by ICC, but is bound by ECHR. And they have said, first of all, there is effective control. Second, administrative practices regards the killing of civilians and forcing and torching and looting of houses in Georgia's villages, they are responsible for it. And in the buffer zone, of course, as well, for inhuman and degrading treatment, Article 5, they are responsible. And for the administrative practice as regards the conditions of detention of Georgian civilians and the humiliating acts to which they were exposed, they also have responsibilities. And finally, arbitrary detention, so which means almost all the articles that were brought into question by Georgia have been answered positively by the ECHR, which opens now the way first for the second case that has been mentioned by Minister Becker, but also for the ICC, because the ICC investigation has been opened proprio motu. That means they have been opened by the prosecutor and not on the request of a state. That is one thing that is not that frequent. It is done when somebody has a country has a big problem, has not come to the ICC, but the prosecutor has seen through preliminary investigations that there is a real case, and brought this case himself or herself, in this case herself, to the Security Council. Now, in the Security Council, we have Russia as well. So this is one thing that we have also to take into consideration. Now, it says that in the ICC, we have crimes committed now by Georgia, by Georgian nationals, or on its territory. Yeah? And we have had now the situation from the ECHR, who says there is effective control over Ossetia. So here the situation comes together. Yeah. Now, Russia does not recognize the ICC, and whatever Russia says, whatever the ICC says, Russia has the possibility to say, I cannot care less. Most of the time, they are not that impolite, because that is not, how would I say, practice, diplomatic practice. But it's very, very easily possible that they will not accept whatever comes out there. But it will help the investigation already. And the inquiries will help to establish not only what Georgians have done, because a court always has the duty to ask the question, why? So if Georgians have done something, why have they done something? And this why could open the possibility to find out about what has happened to trigger it from the other side. So it's already a possibility to establish things also without the collaboration of Russia, and that also might be helpful. There are other things that can be helpful, but maybe my time is over and I can speak about what I really want to say, a means to overcome difficulties later on. Or should I continue? What do you think?
Let's get back to that slightly later on. I have several follow-up questions, but just a brief one for me and for the participants to understand properly. You referred in your remarks earlier to the fact that there is a difference between the crimes committed during the 5-day war and after and before the 5-day war. So could you—
For the ECHR, for the ECHR, yes.
For the ECHR, for the European Court of Human Rights. So could you just very briefly explain what implications that has in terms of the crimes committed during the 5 days war?
Yes. Concerning these crimes committed, let's say by we have to find out who committed which kind of crimes. Georgians committed some crimes, and in that war, maybe Russians committed some crimes, and Ossetians committed some crimes. Yeah, so that has to be later on, for instance, by the ICC, to be taken on and to be said. What the ECHR established was only during wartime. During wartime, Russia was not responsible for what Ossetians have done during the war. Yeah. But immediately after the war, they are responsible for it, because then they have effective control over the country. And as immediately after the war, quite a lot of crimes were committed from all sides, most probably. That is not yet established, because I do not want to establish something that the ICC has not yet established, but therefore I say probably. Then for Russia, there is the situation that they are responsible as well for what Ossetians have done, because they have the control over them. That is the difference. the Georgians are always responsible for themselves.
Of course. Thank you so much. Let me turn to Ambassador Eisen. You have extensive experience in both international and national law, but you're also aware very much so on regarding the international intricacies of these. The ICC is not recognized by Russia, but neither by the United States. But on the other hand, the Georgia-US partnership is extensive, and the US has been Georgia's most important partner and support following the 2008 war. Does progress in the case of the ICC have any bearing on the bilateral relationship, either between the United States and Georgia or between the United States and Russia, in your view?
Thank you, Yulia, for having me, and I want to thank MEI. The answer to your question is yes. I want to say what a pleasure it is to be here with Justice Winter and Minister Damashvili. When I worked in the Obama White House, to explain why the answer to that question is yes, there's a tradition that every new president redecorates the Oval Office. And that planning is happening right now for President Biden. And when the first meetings we had in the Obama Oval Office were in the Bush decor, and then Obama brought his in, and he had a rug custom made, and he had this most important sayings that guided him on the rug. And one of those sayings was a quote that Dr. Martin Luther King Jr. said: "The arc of the moral universe is long, but it bends towards justice." And I think both the proceedings that have been opened at the ICC, the findings, the very important findings that have been referred to at the ECHR, have a gradual teleological effect on on obtaining justice. I wish it were a faster effect. And as you know, the United States has a very complex relationship with the ICC. Presidents have waffled since Bill Clinton signed the Rome Declaration, but refused to submit the treaty to the United States Congress. The United States is very particular about submitting to the jurisdiction of any international authorities. We even have a very conflicted relationship with the UN, despite the fact that it sits on US soil. And so how much more so for China and Russia? And of course here, as Justice Winter noted, the challenge contextually, the challenge is that, of course, Russia also is not fully subject, nor is the breakaway purported refusal to participate of the breakaway Georgian region. But despite all of that, I do think that the movement in the ICC and the ECHR, and it has to be taken together, and the potential now in a new Biden administration, Secretary of State Blinken just testified about this, and you could see the tension in US policy. I watched, he was my colleague, of course, in the Obama administration, and a very old friend of mine from when we were all youngsters together in Washington, DC, 25 years ago, when he was working in the Clinton National Security Council, first started talking to now Secretary Blinken about these issues. And of course, you know his family history, rooted in Europe, including his stepfather, Sam Pisar, himself a victim of just the kinds of 20th century crimes on European soil that make it so necessary to have an ICC. So you have a very sympathetic American Secretary of State and a president who understands deeply the need for justice. So coming back to your question, yes, I think these are events that inch the moral arc of the universe forward. You know, it will be because principally because of Russia's refusal to submit to the jurisdiction of the ICC. We face an uphill climb. That's why the ECHR findings are so important, particularly the mistreatment of the prisoners of war and the refugee and repatriation issues. They're so important for advancing that moral progress. And all of us who care about justice, I have to add one more note from the domestic parochial American perspective. I vividly remember I was traveling with then candidate Obama, Senator Obama, when Russia invaded Georgia. And I vividly remember the discussion inside and the president-to-be's moral reaction. And we all share that horror at the behavior of Russia. And of course, what it did in Georgia was a forecast of what it would do in Ukraine. And we know this is true in domestic politics in the United States, it's true in the international politics, and it's true in the ICC, that if there is no accountability, the crimes will repeat. They will repeat. That is the whole thesis, to end these heinous crimes that the ICC addresses. So I think it's so the answer to your question is yes, not as fast as we would all like, but yes, it represents progress. And hopefully we have a new US administration who will push these issues forward, including NATO membership. We must have NATO membership for Georgia as a deterrence, as the Secretary of State said in his testimony. Once a nation joins NATO, there is deterrence. We need that deterrence towards Russia.
Thank you, Norm, for this overview of parochial domestic issues in the United States, but how that also influences now in a democratic administration the views of the United States when it comes to justice in Eastern Europe. Let me piggyback slightly on that and turn to Becca. In terms of the ECHR, it's been declared in Georgia, and rightfully so, of historical significance. And I would argue not just for Georgia, but for the entire former Soviet space. ICC has been the first case in Eastern Europe, and the decision in the ECHR is historic, and perhaps creates some precedent for what will be going on with the Ukraine cases that are still under debate. So could you, from your perspective, watching these cases so closely, but also being aware of the issues in the former Soviet space that Georgia has been struggling with, along with other partners of the West, Ukraine, Moldova, and others, would you explain to us why this decision is so historically important, both for Georgia and for the former Soviet space?
Thank you, Julia. Firstly, I would like to seize this opportunity and react on the previous panelists' statement. I would like to thank Ambassador Norm for extending support towards Georgia, including supporting Georgia's NATO membership. That is a really huge aspiration for us, which has grounds in Georgian constitution, that Georgian states should move towards full integration into Euro-Atlantic institutions. Getting back to Justice Winter's comment, I would like just to have a small clarification. Yes, European Court found that it could not establish a responsibility of Russia during the active phase of hostilities. But the reason was not because the court thought that Russia did not control Ossetians or the territory. The reason was broader, which would have broader implications for any other state. The court said that it is not ready to examine the cases like Georgia versus Russia when the hostilities are taking place during the active phase of war. And the court indicated that this type of dispute should not be regulated or examined in the prism of European Convention, but rather international humanitarian law and the law of armed conflicts are applicable. And this brings me back to what we all underlined, that why this judgment is relevant for ICC, because the court indicated that IHL and norms relating to the armed conflicts are applicable, and definitely IHL and Rome Statute are basis for international criminal court. So the European Court directed the case, this active phase, to ICC indirectly. And when it comes to the responsibility of Russia, European Court also found the responsibility of Russia during the active phase of hostilities. When it comes to Article 2, right to life, the court said that Russia was responsible for investigation. So in terms of procedural violation, it was the court's finding that Russia was responsible for this violation, which means that in the from the court standpoint, also during the active phase of hostilities, it was Russia's responsibility. So this is also very important finding. And getting back to the ambassadors and your question, what's the most important part from this judgment? This judgment really creates precedent. It is precedent setting. Firstly, for Georgia, because as I said, we have another interstate case, and there are also individual applications against Russia regarding these wars, and many individual applications can be lodged against Russia. And now we have already solved the issue, whether Russia exercised or not effective control, and the court has already decided this. So any case, any future case, or any ongoing case before the European Court, this issue is decided. So Russia exercises effective control, and it would be responsible for all these violations. When it comes to Ukraine, of course, the situation is slightly different, and every case has its peculiarities. But of course, the findings with respect to the, for example, evidentiary basis, the court's approach, what type of evidence would be sufficient for it to find violation is very important, and it would be precedent for Ukrainian cases, because the court easily found Russia's effective control because of military presence, because of support to these proxy authorities, and we see that more or less we have the same situation in Ukraine. Or also that case could be helpful for Moldova. In case of Moldova, we had individual applications where the court already found Russia's effective control. But this case could be also helpful for states like this. And the most important is that we have now ongoing violations by Russia, that kidnappings of the Georgian citizens. And now, after this judgment, any such violation would be directly linked to Russia. Russia could no longer indicate that this is Ossetian authorities or Abkhazian authorities that they are violating something. Now, after the court's judgment, it would be direct responsibility of Russia, and we find the most important finding in this judgment, in this aspect, on ongoing violation of anything happens now, it would be attributed to Russian Federation.
Thank you, Becca. This is a very useful overview and explanation for us to understand better in terms of responsibility of Russia, that we all know is the perpetrator of these frozen and non-frozen occupied conflicts in territories in the region. Let me turn to Justice Winter with two really separate, if you want to tackle one or both of them, questions regarding some of the remarks that we've discussed already. The first one is on the boundness, the responsibility, and the way of implementing decisions following the ruling of the ECHR with Russia. Russia, we discussed, recognizes the ECHR, but can return to a non-recognition, to a rejection of the ECHR anytime, as it is the case sometimes with international law. So the first question would be, how do you see the possibilities of bringing justice in this case and holding Russia accountable for the findings and the ruling that includes the findings of the ECHR? And the second one is something, the second question is something that you alluded to and is important to discuss. We know that in the case of Georgia and others, these countries are seeking justice in a peaceful and diplomatic way, and it's an important issue to discuss. So how can we, with this in mind, how can we think about political mediation and political negotiation to get to constructive results in a difficult relationship with Russia, with everything in mind?
Once again, thank you very much. I wanted just to answer to Minister Becker, because I think there was a misunderstanding. I said in the beginning, all three Ossetians, Russians, and Georgians are responsible during the war. But after the war, Russia is responsible also for everything that has been done by Ossetians, which does, and this is the point, and it does not mean, and I have not said that Russia was not responsible for his own deeds during the war. That's just to fix that. Yeah, for concerning responsibility and implementation, that's always two completely different things. It is now clear, and it has been established, it doesn't need to be established again, that for everything after the war, Russia is responsible. And it has been mentioned already exactly which articles of the law have been breached. It were 8 articles, and some of them have been mentioned. The most important for the people are for the victims, of course, are reparations, and to know if ever they will come back in their country, yes or no. The court cannot force. The court has no military. The court has no anything to force the implementation of its judgments. There are possibilities, and there are. Mr. Eisen used the word moral, but moral is very important and assisting, but moral is not possible to be enforced, and that is the big problem. So I do think that there are ways to address Russia, because also Russia doesn't like, I mean, we can say, or people say Russia doesn't care of this or that and so forth, but Russia also does not like to be accused of something and to be found guilty of something. Yeah, this is internationally not very well accepted, and not so. It might be that there are other possibilities to interest Russia to implement what the court has said. I have been living and working now in Georgia for 10 years. I do think that I do know a little bit of the situation, the real situation in the country, like the minister. And there is not very much, there are not very much possibility to force Russia to do something. NATO is certainly a very good idea, but it might be that the attempt to be part of NATO will be very dangerous for Georgia as well. It might be seen as an affront, and it might be trigger another military problem. But there are other possibilities, and Georgia has, and the people of Georgia since years have in practice on that, and this is mediation. We have to take into consideration the fact that we cannot force Russia, not really. We have to take into consideration that Russia does not seem to be interested at all in solving any of his territorial conflicts, neither in Transnistria, nor in the Ukraine, nor in Georgia. Quite on the contrary, they are not that interested in doing that. But maybe now, with the possibility to see that there is an ongoing investigation that brings up things that Russia maybe would not like that much, that we have a possibility to ask if mediation would be possible, because political mediation means that the two parties, in this case Russia and Georgia, would find a person from a country they both agree on, let's say country X, and a person from country X they also agree on, to find out if there are issues, some issues that would be solvable in the interest of both. This is always a beginning of a mediation, and there could be such things. The situation of the borderline, of the people living on the borderline, is disastrous, really, really difficult. But it is also no fun for the Ossetians or the Abkhazians living there on the border side. Because they're also occupied one way or the other. If they agree or not, some agree, some don't. It's not a very pleasant situation. And it is also not a very pleasant situation for everyone else who, sorry, I have a problem now, it's solved, is who has financial burdens. If Russia has a responsibility for these regions, it's not for free. It costs them quite some money. And it might be a possibility to bring both to the table and to say, okay, let's see. Is there one thing, maybe a humanitarian corridor? Is there a possibility to that Georgia is doing X, and as an answer, Russia is doing Y? Maybe Georgia can ask for having possibilities to have schools for the border people from both sides. Maybe there could be a hospital for both sides. There are many, many, many possibilities if one wish. The only one thing and the only one problem that we have in this regard is to see if the investigation of the ICC, and I'm coming back to that investigation, is kind of unpleasant and not, I do not care, no, kind of unpleasant to Russia, and that Russia would be interested in showing they are not always the bad guys. They have interests as well that they would like to have solved together with Georgia. For the moment, together is not possible, but maybe via a mediation, slow by slow and millimeter by millimeter, there might be a possibility. It has happened after World War II in Europe, in several regions, in my own Austria. It has worked like that. Maybe we have a millimeter, centimeter, meter chance.
May I? agreed, except I fully embrace the idea of mediation and of utilizing the ECHR and the ICC moral force. I do think that the law, philosophically, this could be a whole other subject, without the animation of its moral content, the law is purely formalistic. So the energy, we don't always do it perfectly, but as a ethicist, the animating force is that moral energy within the law. The only thing I would say to the risk is that the lived experience of NATO membership is that NATO membership is actually a deterrence to the kind of continued aggression. There was a colloquy between Senator Rand Paul and Secretary of State Blinken about this very point, when Rand Paul said, oh, if you're supporting Georgia and NATO, won't you be drawing the United States in because of Article 5, the obligation to defend? It works the other way. It's a deterrence. So I think the NATO question is an important one, but certainly the notion of applying the successful examples of mediation. Personally, as a lawyer, I've settled many cases through mediation. It only works, I find it only works when the parties are both feeling the pressure of about to go to trial. So my best mediations come the night before I'm about to take a painful deposition of the other side. I say, oh, I better mediate. So we need those external pressures to animate the mediations. And I also am acutely aware of failed mediations. They don't always work. And we have these lingering, decades. And in the United States, we have a centuries-long conflict. The mediation after the Civil War, which we call Reconstruction, it did not work. So sometimes strength, particularly in dealing with Russia, sometimes there's a role for strength. And if the United States and the EU and NATO are not willing to stand up for a country that has been bullied, this is a little, for myself as a Democrat, I'm more in the more vigorous side of the Democratic Party on these issues. If we're not willing to stand up for victimized, bullied countries, where is our moral stature that animates the American project? What right do we have to talk to anyone else anywhere in the world if we're not willing to take that moral and ethical stand on behalf of countries like Georgia?
Sorry to answer, if I may, very shortly.
Go ahead, please.
As I said, I have been working for the European Union in Georgia now for 10 years. And we have always worked together with the UN, with the US. And in this regard, the US has not spoken about force, has spoken about assistance, has spoken about law, has spoken of implementing laws. And the European Union brought also the mediation to the table, also about laws and so on. It was assistance and not force. Force was certainly there. It's not at least not my part, but I have seen, I have been judging in the Balkans, and I have seen that mediation can work when the law cannot work anymore. I have been working in Africa. I was president of the Special Court of Sierra Leone, and the peace agreement worked only then when the three parties finally came to a table. And the situation now between Russia and Georgia is a bit different, because the Balkan countries or the tribes in Africa have been more or less similarly strong, which is very good for a mediation. In the case of Georgia, you have a very small country and a very huge one with some resources and another one with huge military resources. There, the balance is for mediation is not optimal in the beginning. But by trying with possibilities, as I said, humanitarian possibilities, like a corridor, a humanitarian assistance for both sides, there might be a possibility for an opening. It does not say that NATO is not important, but it is one leg. We march by far better on two legs. No?
Agreed.
And if Russia,
3 legs. Let's have 3.
If Russia would not accept force or answer force by force, maybe a mediation between Russia and Georgia finds other assistance. Maybe, I do not say it will work, but I would like to try, believe me. Thank you.
Let's see. I think from I don't want to speak from the Georgian side. I'm still in the process of learning, but I think the ideal version would be the US forceful and Russia open to mediation. But I can tell you this much, that I think we've seen over the last few months, going back to big US international policy, that Russia has not been thrilled by Biden. And now I see why. If there's neocons among Democrats like Norm Eisen, that doesn't look good for Russia.
I am not, my views are beyond even these strong views of that the Secretary of State expressed in his hearing. Myself, as the child of 2 European refugees and a Holocaust survivor, I feel very strongly about an all of the above deterrence approach at the first sign of aggression. So my views are to the right, even in the Democratic Party.
Definitely.
But maybe it would be a very good idea to ask the minister, because I do think that Georgia has his word to say, if they would at least be from their side interested in having, besides strengths, also something else, yes or no. Mediation within Georgia works very well. Let's see what the minister says, because maybe he has other problems with it, or has problems that we have not dealt with.
I was just about to turn to Deputy Minister Zamashvili for, we have about 5 minutes left. If you could, instead of closing remarks, offer us your view on the issues that we've just discussed, maybe drifting slightly away from not the topic of our conversation today, NATO, but rather the implications of the ICC and ECHR cases in terms of political mediation, and in terms of what, from the Ministry of Justice of Georgia perspective, what are the next steps that Georgia is aiming for and hoping for to make progress already to the substantial realizations that you have already made with this victorious ruling of the ECHR from the Georgian perspective. So if you could give us an overview of what you expect and what you wish for from us to the Georgian side, and what are the next steps from your perspective?
Thank you. I underlined in my introductory statement that Georgia tries to resolve this dispute with peaceful and legal means. And in this proposition, definitely aspiration towards NATO and European Union absolutely perfectly fits in, because membership of NATO or European Union is not against any state, including against Russia. It's just only to strengthen Georgian state and to have peaceful relations with all the neighbors. Like the good example is, of course, the Baltic states, right? So I agree. As Ambassador underlined, that it could have effect of deterrence rather than causing further conflict. But at the same time, of course, we are open for all type of discussions. I would not call it mediation, but as you know, there is ongoing discussions at Geneva discussions, which takes place 4 times a year. and we have very good platform where both United States and European Union are participating there as well. And I think this judgment gives further impetus to this format, because the court explicitly mentioned that the dispute should be resolved, and the Geneva discussions are very good platform for that. So this is explicitly mentioned in the European Court judgment. And I think the court clarified very important issues. So until now, there was discussion whether Russia was responsible or not for several violations. But after that, in Geneva, our diplomats would have a very strong document that any violations that takes place in the occupied territories is attributed to Russia. And we are going to use all diplomatic, political, or legal platforms to dwell on this judgment and to resolve the dispute, being it within United Nations, Council of Europe, OSCE, or other multilateral, bilateral platforms that could exist. Our approach would be definitely peaceful means, legal means, but at the same time, if Georgia aspires to strengthen its state by joining various international organizations, definitely it would not be against any other state. It would be only to strengthen the state and to have peaceful relations with all the neighbors.
Thank you, Minister Zamashvili. And with that, with only 1 minute to go, I would like to take this opportunity to thank all of our panelists, Minister Zamashvili, Ambassador Eisen, Justice Winter, for this fantastic discussion. I'm glad that it turned out to be a lively discussion in which we were able to discuss the ICC, the ECHR, and the search for the pursuit for justice of Georgia, and the amazing progress that it has made, and the implications for the larger space of Central and Eastern Europe. Thank you also for to all our participants for joining this conversation. I hope it was interesting to all of you, and I hope I was able to weigh in as many of your questions into the discussion. I saw that on the Q&A function, it was at least as lively as it was in the live discussion. Thank you everyone again on behalf of MEI Frontier Europe for your time and for your participation and insights, and hope to see you all soon. Have a good morning, afternoon, and evening wherever you are, Vienna, Tbilisi, and DC. Thank you so much.